My first live, and what better to do it the day after the Independence Day, right? So, June 13th, 1967, Congressional Record, of House, page 15,641. This has to do with Mr. Rarick. He was the Speaker of the House from Louisiana. So, Mr. Speaker, arrogantly ignoring clear-cut expressions in the Constitution of the United States, the declared intent of its drafters notwithstanding, our elected federal judges read out prohibitions of the Constitution of the United States by adopting the fuzzy haze of the 14th Amendment to legislate their personal ideas, prejudices, theories, guilt, complexes, aims, and whims. Through the cooperation of intellectual educators, we have subjected ourselves to accept destructive use and meaning of words and phrases. We blindly accept new meanings and change values to alter our traditional thoughts. We have tolerantly permitted the habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, the present use and expansion of the 14th Amendment is a sham. Why would he call it a sham? Serving as a crutch and hoodwink to precipitate a quasi-legal approach to overthrow of the tender balances and protections of limitation found in the Constitution. So they already usurped and found a way to get around and pierce your constitutional protections. But interestingly enough, the 14th Amendment, whether ratified or not, we're going to get into why it wasn't constitutionally ratified, was but the expression of emotional outpouring of public sentiment following the war between the states. The Civil War is what he's referring to. Its obvious purpose and intent was but to free human beings from ownership as chattel by other humans. Its aim was no more than to free the slaves. As our political appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government by substituting their personal law rationalized under the 14th Amendment. Rationalized. Their actions and verbiage brand them and their team as secessionists, rebels with pens instead of guns, seeking to divide our union. They must be stopped. Public opinion must be aroused. The union must and shall be preserved. Mr. Speaker, I shall include in the record, following my remarks, House Concurrent Resolution 208 of the Louisiana Legislature urging the Congress to declare the 14th Amendment illegal. Also, I include in the record an informative and well-noted treatise on the illegality of the 14th Amendment, the play toy of our secessionist judges, which has been prepared by Judge Linder H. Perez of Louisiana. So, the 14th Amendment is unconstitutional. And this paragraph or this section of this congressional record is actually going to explain exactly how. So the purported 14th Amendment to the United States Constitution is and should be held to be ineffective, invalid, null, and void, and unconstitutional for the following reasons. Let's stop for a second. Hold on, I wasn't totally prepared because I don't have my book, my constitutional, book, so I could actually read the 14th Amendment. Here, I'll pull it up on the computer so we can read it, because this needs to be seen. Nobody's actually done a proper build on this, because not too many people know exactly why it was illegal and how it actually came into part. So, 5 sections, right? I'll read it here. So all persons, remember the preamble of the Constitution says, we the people, This says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And this goes on to say, no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. 2, the representatives shall be appointed among the several states according to their representative numbers, counting the whole number of persons in each state, excluding Indians not taxed, that's me, but when the right to vote in any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of the state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged except for the participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in each state. Remember, at this point in time, this 16th wasn't in place, so it was only men that were allowed to vote. No person shall be a senator, representative of Congress, or elector of the president and the vice president, or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or of any state, sorry, I jumped a line, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4, the validity of the public debt of the United States. This is real important. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection and rebellion, shall not be questioned. So the national debt shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for loss of or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. So the validity of the public debt shall not be questioned, right? Do we know what the public debt is? Let me pull that up for you guys. Let's see. Oh, no, not. Misspelled it. What is not coming up? Debtclock.org is not coming up. 1 second. Put the camera on me so you can see me for a second. Let me check this out. There it is. Bingo. Here we go. It's usdebtclock.org. This is the U.S. national debt. this is the 14th, why the 14th Amendment was questioned and challenged by 11 of the, I think the 36 states of the Union at the time, was because the 14th Amendment and its verbiage, right, and the changes of the language and the meaning of those languages is what they were had contention about. So this is what the national debt is, and you see this in real time. So this is going up. Look at debt per citizen, 103. Now remember, Walmart's a citizen, right? What, not Sears, but I mean, all these stores. McDonald's is a citizen because under the 14th Amendment, all persons born and naturalized are citizens of the United States, right? Well, the word person, and we can look that up too. This is Black's Law Dictionary, 3rd edition. Yeah, this is proof or poof, man. I don't play, man. Like I said, I don't need to. The truth is like a lion. I don't need to protect it. I just let it out and it will protect itself. So this is why, since we're here, people, a state, as the people as the people of the state of New York, a nation in its collective and political capacity. That's what people are. That's what the Constitution preamble states. We the people, right? Well, they turned everyone with the 14th Amendment into, where are we? Where are we? Persons. A man considered according to the rank he holds in society, with all right to which the place he holds entitles him and the duties which it imposes. Now check this out. This one definition, person, in law takes up this whole fucking page. Excuse my profanity, but it's real. The term is, however, more extensive than man. It may include artificial beings as corporations. That's how McDonald's, that's how Walmart, that's how all of these franchises, corporations are also considered U.S. citizens and also hold that national debt of $103,504 per person. Debt per taxpayer is even higher, to $266,000, right? But this number is going up every second by, more money than you can even imagine. But check this out. See, that's in red and that's in green. So their money is going up. The U.S. federal tax revenue. It's because the banking system is a Ponzi scheme. See, they took our money in 33, and I could dive into that too, but I want to stay on track right now. So, the 14th Amendment, the purported 14th Amendment to the United States Constitution is and should be held to be ineffective, invalid, null and void, and unconstitutional for the following reasons. 1, the joint resolution proposing said amendment was not submitted to or adopted by a constitutional Congress. Article 1, Section 3, and Article 5 of the Constitution, states that everything needs to be, submitted to the legislature in according fashion. I gotta grab my book so you can actually see. The joint resolution, number 2, the joint resolution was not submitted to the president for his approval. Article 1, Section 7. Number 3, the proposed 14th Amendment was rejected by more than 1/4 of all states then in the Union, and it was never ratified by 3/4 of all the states in the Union, according to Article 5. The unconstitutional Congress. The U.S. Constitution provides in Article 1, Section 3 that the Senate of the United States shall be composed of 2 senators from each state, right? Article 5 provides that no state without its consent shall be deprived of its equal suffrage in the Senate. Let's look up what suffrage means. Most people don't. That's a new word for a lot of people. Most people don't know what suffrage means. So Let's look it up in the law dictionary, because remember, law and history are coincide. So we must, look up these definitions in law. Suffrage, simply put, is a vote, the act of voting, the right or privilege of casting a vote at public elections. The last is the meaning of the term in such phrases as the extension of suffrage, universal suffrage, etc., right? Participation in the suffrage is not of a right, but is granted by the state on the consideration of what is most for the interest of the state. Okay? So we know what suffrage means now, right? So it says here that no state shall provide consent shall be deprived of its equal suffrage in the Senate. The fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for adoption of the joint resolution proposing the 14th Amendment is shown by resolutions. Wait, is that the right? I got these mixed up. Nope, that's the right page. Is shown by the resolutions protests adopted by the following state legislatures. The New Jersey legislature, by resolution of March 27, 1868, protested as follows. They said proposed amendment not having yet received the assent of the 3/4 of the states, which is necessary to make it valid, the natural and constitutional right of this state to withdraw its assent is undeniable. That is being necessary by the Constitution that every amendment to the same should be proposed by 2/3 of both House of Congress, the authors of said proposition, for the purposes of securing the assent of the requisite majority, determined to and did exclude from the said two houses 80 representatives from 11 states of the Union, upon the pretense that there were no such states in the Union, but finding that 2/3 of the remainder of the said houses could not be brought to assent to the said proposition, they deliberately formed and carried out the design of mutilating the integrity of the United States Senate, and without any pretext or justification other than the possession of the power without the right, and in the palpable violation of the Constitution, ejected a member of their own body representing this state, and thus practically denied to New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of 2/3 of the said houses, right? And it goes on. Like I said, I can go. 11 southern states, including South Carolina, are deprived of their representation in Congress, although the senators and representatives have been duly elected and have presented themselves for the purpose of taking their seats. Their credentials have, in most instances, been laid upon the table without being read, or have been referred to a committee who have failed to make any report on the subject. In short, Congress has refused to exercise its constitutional functions and decided either upon the election, the return, or the qualification of these selected by the states and people to represent us. Some of the senators and representatives from the southern states were prepared to take the test oath, but even these have been persistently ignored and kept out of the seats to which they were entitled under the Constitution and the laws, right? Hence, this amendment has not been proposed by 2/3 of both houses of a legally constituted Congress, and is not constitutionally or legitimately before a single legislature for ratification, right? So, joint resolution ineffective. Article 1, Section 7 provides that not only every bill which shall have been passed by the House of Representatives and the Senate of the United States, but every order, resolution, or vote to which the concurrence of the Senate of the House Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives, according to the rules and limitations prescribed in the case of a bill. So we go down here and it says, number 3, proposed amendment never ratified by 3/4 of the state, right? Texas rejected the 14th Amendment October 27, 1866. Georgia rejected the 14th Amendment November 9th, 1866. You want to see some proof about Georgia? Hold on, I got that here too. Hold on one second. What's that say? State of Georgia. That's under seal, right? This is the Georgia Archives, right? And it says here, Christopher M. Davidson, Georgia Archives, do hereby certify that the 3 pages document hereto attached and made part of this certification is a true and correct copy of the entire file for Act number 45, SR 39, approved March 8, 1957, a memorial to the Congress of the United States of America, urging them to enact such legislation as they deem fit to declare that the 14th and 15th Amendments to the Constitution of the United States were never validly adopted, and I further certify that the described act on file and of official record in the archives of the state of Georgia, right? And it goes on to this resolution is on file in the Georgia archives in their records, right? Together with 10 other southern states declared to have been lately in rebellion against the United States following the termination of hostilities in 1865, right? Met all constitutions, met all the conditions laid down by the President of the United States in the exercise of his constitutional powers to recognize the governments of states, domestic as well as foreign, for the resumption of practical relations with the government of the United States, and at the direction of the President did elect senators and representatives to the 39th Congress of the United States as a state and states in proper constitutional relation to the United States, right? So it goes on to talk about the same thing that we're already discussing, but if you want to look it up, Georgia Archives, it actually breaks that down. So Georgia rejected it, Florida rejected it, Alabama rejected it, North Carolina rejected it, Arkansas rejected it, South Carolina rejected it, Kentucky rejected it, and goes on. Virginia rejected it, Louisiana rejected it, Delaware rejected it, Maryland rejected it, Mississippi, Ohio, and New Jersey all rejected this 14th Amendment, right? So the 13th Amendment was ratified by 27 states, and the then 36 states of the Union, including the southern states of Virginia, Louisiana, Arkansas, South Carolina, Alabama, North Carolina, and Georgia. This is shown by proclamation of the Secretary of State, December 18, 1865. Without votes of these 7 southern states, legislatures, the 13th Amendment would have failed. There can be no doubt but that the ratification of these southern states of the 13th Amendment again established the fact that the legislature and the state governments were duly lawfully constituted and functioning as such under the state constitution. So what that basically says is that these same 11 states, right, that just rejected the 14th Amendment were included when they passed and signed and agreed to secure the necessary votes to pass the 13th Amendment. So if they were included for the 13th Amendment. This is, after 1865, as it says right there, right? December 18th, 1865, right? So if they were included in this vote, how could they not be included in the vote for the 14th Amendment, right? And this is because the 14th Amendment has those clauses that are very vague and, can be manipulated for those in power. So when the state of Louisiana rejected the 14th Amendment on February 6, 1867, making the 10th state to have rejected the same, or more than 1/4 of the total number of 36 states of the Union as of that date, thus leaving less than 3/4 of the states possibly to ratify the same. The amendment failed of ratification in fact and in law, and it could not have been revised except by a new joint resolution of the Senate and the House of Representatives in accordance with the constitutional requirement, right? So, faced with positive failure of the ratification of the 14th Amendment, both houses and Congress passed over the veto of the president 3 acts known as Reconstruction Acts between the dates of March 2nd and July 7th of 1867, especially the third of said acts, 15 stat, page 14, etc., designed illegally to remove the military force and lawfully constituted state legislatures of the 10 southern states of Virginia, North Carolina, South Carolina, Georgia, Florida, Alabama, Mississippi, Arkansas, Louisiana, and Texas. In President Andrew Johnson's veto message on the Reconstruction of March 2nd, 1867, he pointed out these unconstitutionalities. If ever the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he can live. He is to live. That work is his work, and it cannot properly be taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution except such as may be arbitrarily dictated by Congress and formed under the restraint of military rule. A plain statement of facts makes this evident. In all these states, there are existing constitutions framed in the accustomed way by the people. Congress, however, declares that these constitutions are not loyal and republican and requires the people to form them anew. What then, in my opinion, of the Congress is necessary to make the Constitution of a state loyal and republican? The original act answers the question. It is universal Negro suffrage, a question which the federal Constitution leaves exclusively to the states themselves. All of the legislative machinery of the martial law, military coercion, and political disenfranchisement is avowedly for the purpose and none other. The existing constitutions of the 10 states conform to the knowledge standards of loyalty and republicanism. Indeed, if there are degrees in republican forms of government, their constitutions are more republican now than when the states, 4 of which were members of the original 13, first became members of the Union. In President Andrew Johnson's veto message on the Reconstruction Act of July 19th, 1867, he pointed out various unconstitutionalities as follows. The veto of the original bill of the 2nd of March was based on 2 distinct grounds. The interference of the Congress in matters strictly appertaining to the reserved powers of the states and the establishment of military tribunals for the trial of citizens in the time of peace. Let's jump down to, I want to touch base on something else, right? So what basically happened was through, I think it breaks it down here. Where is it on the next page? Yeah, this, this, we can touch on this. All right, so yeah, let's touch on this. The 10 states were organized into military districts under the Unconstitutional Reconstruction Act. So they took the 10 states and put them under military, control, and removed by military force, and they replaced by rump so-called legislatures, 7 of which carried out military orders and pretended to ratify the 14th Amendment as follows. So they basically, at gunpoint, pretty much removed the senators that were elected by the people and placed their own senators in their place to falsely pretend to ratify the 14th Amendment. Arkansas is on April 6th, North Carolina, yada, yada, yada. Pause it and read it if you want to. Alabama on July 13th and Georgia on July 21st. Of the above 7 states whose legislatures were removed and replaced by rump so-called legislatures, 6 legislatures of the states of Louisiana, Arkansas, South Carolina, Alabama, North Carolina, and Georgia had ratified the 13th Amendment as shown by Secretary of State's proclamation December 18th, 1865. Without which 6 states' ratification, the 13th Amendment could not and would not have been ratified because said 6 states made a total of 27 out of the 36 states, or exactly 3/4 of the number required by Article 5 of the Constitution for ratification. So this goes back to what we said earlier. If you were able to ratify the 13th Amendment with these legislatures in place, why would they not be allowed to cast their vote under equal suffrage in denial of the 14th Amendment, right? So, furthermore, governments of the states of Louisiana, Arkansas have been reestablished under a proclamation issued by President Abraham Lincoln, okay? December 8th, 1863. The government of North Carolina had been reestablished under a proclamation issued by Andrew Jackson dated May 29th, 1865. The government of Georgia had been reestablished under a proclamation issued by Andrew Johnson, dated June 17th, 1865. And pause it and read the rest. These 3 Reconstruction Acts, under which the above state legislatures were illegally removed in unlawful rump or puppet so-called legislatures were submitted in a mock effort to ratify the 14th Amendment, were unconstitutional, null and void, ab initio. Do we got to look up what ab initio? Ab initio means from the beginning. So let's look it up just so you guys, don't take my word for it. Proof for poof. So we're going to go look up for ab initio in the Black's Law Dictionary. Here we go. Ab initio, Latin, from the beginning, from the first act, entirely, as to all acts done. In the inception, a party may be said to be a trespasser and a state to be good, an agreement or deed to be void, a marriage or act to be unlawful, ab initio. So let's go back. Where are we at? Null and void, ab initio, and all acts done thereunder were also null and void, including the purported ratification of the 14th Amendment by said 6 Southern puppet state legislatures of Arkansas, North Carolina, Louisiana, South Carolina, Alabama, and Georgia. Those Reconstruction Acts of Congress and all acts and things unlawfully done thereunder were in violation of Article 4, Section 4 of the United States Constitution, which required the United States to guarantee every state of the Union a Republican form of government. They violated Article 1, Section 3, and Article 5 of the Constitution, which entitled every state in the Union 2 senators, because under provisions of these unlawful acts of Congress, 10 states were deprived of having 2 senators or equal suffrage. So they didn't place 2 senators in place. They removed the lawfully elected senators and placed 1 in their place that had agreed to sign and ratify the 14th Amendment. The Secretary of State expressed doubt as to whether 3/4 of the required states had ratified the 14th Amendment, as shown by his proclamation on July 20th, 1868. Promptly on July 21st, 1868, a joint resolution was adopted by the Senate and House of Representatives declaring that 3/4 of the several states of the Union had ratified the 14th Amendment. That resolution, however, included purported ratifications by the unlawful puppet legislatures of the 5 states, Arkansas, North Carolina, Louisiana, South Carolina, Alabama, which had previously rejected the 14th Amendment by action of the lawfully constituted legislature as above shown. The joint resolution assumed to perform the function of the Secretary of State, in whom Congress, by act of April 20th, 1818, had vested the function of issuing such proclamation declaring the ratification of constitutional amendments. The Secretary of State bowed to the action of Congress and issued his proclamation of July 28, 1868, in which he stated that he was acting under authority of the act of April 20th, 1818, but pursuant to said resolution of July 21st, 1868. He listed 3/4 or so of the then 37 states as having ratified the 14th Amendment, including the purported ratification of the unlawful puppet legislatures of the states of Arkansas, North Carolina, Louisiana, South Carolina, and Alabama. Without said 5 unlawful purported ratifications, there would have only 25 states left to ratify out of 37, when a minimum of 28 states is required for ratification by 3/4 of the state of the Union. The joint resolution of Congress and the resultant proclamation of the Secretary of State also included purported ratification by the states of Ohio and New Jersey, although the proclamation recognized the fact that the legislatures of said states several months previously had withdrawn their ratification and effectively rejected the 14th Amendment on January 1868 and April of 1868. Therefore, deducting these 2 states from the purported ratifications of the 14th Amendment, only 23 state ratifications at most could be claimed, whereas the ratification of 28 states, or 3/4 of the 37 states of the Union, were required for 14th Amendment. So even there, they didn't have enough, but they just forced this thing. This was why it's unconstitutional. From all of the above documented historic facts, it is inescapable that the 14th Amendment was never validly adopted as an article of the Constitution, that it has no legal effect, and it should be declared by the courts to be unconstitutional, therefore null and void and of no effect. Okay? The legislature of Georgia, North Carolina, and South Carolina had rejected the amendment in November and December of 1866. New governments were erected in those states and in others under the direction of Congress. The new legislatures ratified the amendment. that of North Carolina on July 4th, and that of South Carolina on July 9th, and that of Georgia, July 21st of 1868. So I'm just going through these highlights, man, because I wanted to touch the new governments were erected in those states. You know, like I said, I just said that the U.S. Supreme Court overlooked that it previously had held that at no time were the southern states out of the Union. So the Supreme Court already, they overlooked the fact that at no time the southern states were not part of the Union. They always have been part of the Union. Well, not always, since the conclusion of the Civil War. So the court ignored the fact that other 6 southern states, which were given the same treatment by Congress under the unconstitutional Reconstruction Acts, all had legal constitutions and a Republican form of government in each state, as was recognized by Congress by its admission of those states into the Union. The court certainly must take judicial cognizance of the fact that before a new state is admitted by Congress into the Union, Congress enacts an enabling act to enable the inhabitants of the territory to adopt a constitution to set up a Republican form of government as a condition precedent to the admission of the state into the Union. And upon approval of such constitution, the Congress then passes an act of admission of such state. All of this was ignored and brushed aside by the court in the Coleman case. However, in Coleman, the court inadvertently said this: whenever official notice is received at a Department of State that any amendment proposed to the Constitution of the United States has been adopted according to the provisions of the Constitution, the Secretary of State shall forthwith cause the amendment to be published, and with his certificate specifying the states by which the same may have been adopted, and that the same has become valid to all intents and purposes as part of the Constitution of the United States. Hawk versus Smith. So let's just jump down here. I should read this whole thing. The 5th article is a grant of authority by the people to Congress. The people to Congress. In a republic, the people had the power, right? But now in your democracy, that power has been usurped. So the 5th article is a grant of authority by the people to Congress. The determination of the method of ratification is the exercise of a national power specifically granted by the Constitution. That power is conferred upon Congress and is limited to 2 methods: by action of legislatures or 3/4 of the states, or in conventions in like number of states. Dodge versus Woolsey. The framers of the Constitution might have adopted a different method. Ratification might have been left to vote of the people or some authority of government other than that selected. The language of the article is plain and admits of no doubt in its interpretation. It is not the function of the courts or legislative bodies, national or state, to alter the method which the Constitution has fixed, meaning it can't be moved or changed. We submit that in none of the cases in which the court avoided the constitutional issues involved in the composition of the Congress which adopted the joint resolution of the 14th Amendment. The constitutional requirements set forth in Article 5 of the Constitution permit the Congress to propose amendments only whenever 2/3 of both houses shall deem it necessary. That is, 2/3 of both houses as then constituted without forcible ejections. Such fragmentary Congress also violated the constitutional requirements of Article 5 that no state without its consent shall be deprived of equal suffrage of the Senate. So the 14th Amendment is illegal, it's unconstitutional, and was never ratified. And with the Act of 1871, which I'll read here, the formation of Washington, D.C., or the District of Columbia, this is 41st Congress, Session 3, Chapter 31, 61 and 62, 1871, page 419. We're going to jump down to this chapter, right? So, be it enacted by the Senate of the House of Representatives of the United States of America in Congress assembled. Notice it says United States of America in Congress assembled, right? That all that part of the territories of the United States included within the limits of the District of Columbia be and the same is hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes. Okay, well, let's find out what a body corporate is. If you follow me already and you've seen some of my other videos, we've already looked at this definition, right? But we're going to look it up right now in the middle of this so you guys can see what a body corporate is. A corporation. An early and correct term to apply to a corporation. That's it. In law, this body corporate, right there, for municipal purposes. Let's look up what municipal means. Okay, let's go. It's definitions. Proof or poof, as my big brother says. Municipal. Municipal purposes, public or governmental purposes as distinguished from private purposes, okay? So, municipal corporation, a public corporation created by government for political purposes and having subordinate and local powers of legislation. An incorporation of persons, inhabitants of a particular place or connected with a particular district, enabling them to conduct its local civil government. So the United States is technically the 10 miles of Washington, D.C. Anyways, it goes on to say it may conduct and be contracted with, sue and be sued, plead and be pleaded, have a seal, and exercise all other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States. Wait. United States? United States of America. United States of America. The law is specific. You know the United States is the name of the corporation located at the District of Columbia, and the United States of America is the constitutional republic. This municipal corporation is your democracy, not consistent with the constitutional laws of the United States and the provisions of this act. So, the Independence Day that you celebrated yesterday, you lost it in 1871. And actually 1868 when they created the 14th Amendment and turned everyone into persons instead of the sovereign people that are the global icon for freedom and liberty. And they've just been peeling away your privileges one at a time, generation after generation, until they get complete control. Their aim was to dumb down the public. I can pull that up too. Let's look that up. The philosophy of the General Board of Education. Let's read this. I think everybody needs to see exactly how they were done. Let's look it up. So here we go. I'm in Wikipedia, General Board of Education, General Education Board. Let's scroll down to the philosophy. This is how easy it is. This is why they don't care about doing what they do to you, because they put it right in front of us. They're not doing it under cloaks, behind smoke screens. They put it right in your face. And so because they tell you what they're going to do or what they've done, right, there's no karmatic debt to it, which means that they can do it with impunity because they told you. You stuck your head in the sand and said, oh, I don't care. In our dream, we have limitless resources, and the people yield themselves with perfect docility to our molding hand. The present educational conventions fade from their minds, and unhampered by tradition, we work our own good will upon a grateful and responsive rural folk. We shall not try to make these people or any of their children into philosophers or men of learning or men of science. We have not to raise up from among them authors, editors, poets, or men of letters. We shall not search for embryo great artists, painters, musicians, nor lawyers, doctors, preachers, politicians, statesmen, of whom we have an ample supply. The task we set before ourselves is very simple as well as a very beautiful one. To train these people as we find them to a perfectly ideal life just where they are. So we will organize our children into a little community and teach them to do in a perfect way the things their fathers and mothers are doing in an imperfect way, in their homes, in the shops, and on the farm. School was never meant to educate. It's put in place to indoctrinate, train, and create great little worker bees to do their bidding and do all the menial work and tasks that they've created AI now to replace it. And they're flooding the country, or the perceived country, with immigrants to erase and erode the Constitution that was put in place to protect us all. So that Constitution, those Articles of Confederation came from the indigenous Americans that worked, established, taught these new people how to survive and live and prosper on our land. The history that you were taught, I just read the philosophy of the General Board of Education. That is indoctrination. And the history, his story that they told you, is not the truth about the past. You cannot take what these people are telling you for face value. Do your own research. Don't believe anything. Read everything, listen to everyone, but don't believe anything. Don't even believe me unless you can prove it with your own research. I implore you and challenge you to try to prove what I just showed you guys as wrong or false. Like I did. When I was studying this, I heard it and I was like, okay, well, let me research it and let me actually try to prove it wrong. And in the course of trying to prove it wrong, I proved it right. So I encourage everybody to approach any bit of knowledge or information that you receive in that same fashion. Go out there, try to prove it wrong, and in the case that you prove it right to yourself, pay it forward and share that information with your peers, your friends, your family members, because they have done a perfect, near perfect job on putting the society to sleep and having them think and feel that the republic that they pledge allegiance to in grade school, I don't even know if they do that anymore, right? But There's a mosquito in here. I gotta kill this motherfucker before he eats me up. Excuse my language. They are going to, they fooled everybody into thinking that what they pledge allegiance to in grade school is the same thing that an entity that they're voting for, in November. The left and right wing are part of the same vulture that has been picking the people clean. Skeletons. They have been feasting on the dead. The dead meaning civil litter mortuus, or mortuus civil litter, which means civilly dead people. And the 14th Amendment took away your pulse. So, I don't know how many people tuned into this. I don't know how many people will tune into this, but if you found what I shared with you interesting, thought-provoking, and sound, hit the like button, share the video, subscribe for more content. This is my very first live video. I only started this channel because people who I know, who are close to me, that have gotten a wealth of information from me through our friendship and association, have been urging me to start my platform and start sharing what I know with the people. I'm a poet, so I don't mind performing, getting up here and talking to people, sharing people what I know. So it was just a matter of me actually, putting it together, and after seeing, people really take interest in the finding out about the things that I discovered in my journey, in my search for the truth, I'm excited to bring more content, and I am always open to the possibility that I could be wrong. But I do a lot of research to make sure that I'm, pretty accurate about what I've stated. I wouldn't bring it to you if I hadn't done my research thoroughly, as you can see, on exactly what has transpired. So, could I be wrong? Of course I could be. It's not likely though. So I encourage you to challenge what I've shared with you with facts to the contrary. So don't just say, that's all pseudo history, that's all BS, even though I read it directly from congressional records. So if you have an issue with it and you think that I'm wrong, and you can share facts to the contrary that I can research on my own, because I am going to research it. I'm definitely going to do my own due diligence to make sure and vet it. If it is prove me wrong, I'll be the first person to admit that I was wrong. But I ain't had too many people do that since I've really decided that I wasn't going to be deaf, dumb, and blind. So, appreciate everybody who tunes into this video. Like, share, and subscribe. Got more coming to you. I'm working on, one of these live stream applications, I guess, to engage with YouTube. So still learning, figuring out all the details so that I can actually provide you some content outside of just through this phone. So appreciate you for tuning in. Again, like, share, and subscribe. And I got more content coming towards you. But don't believe anything that I told you. Do your own research, try to prove it wrong, and when you prove it right, pay it forward. And with that being said, I'll leave you with my motto: love everything, fear nothing, and life will love you back. And I love you all. Peace and love.